Hello, hello. Oh, there we are. All right, welcome everybody to the MTAV stage here at Gussapolooza. Thank you guys for being our sponsors today. I'm here to introduce Paul Sanderson. Paul has over 40 years of experience in arts and entertainment law, advising thousands of clients, including major music publishers, independent record companies, and gold and platinum recording artists. He has worked on recording, licensing, and distribution contracts across the globe, including in Canada, the US, Japan, and Europe. Paul is a licensed Canadian trademark agent, an instructor at Metalworks Institute, and co-founder of Artist Legal Advice Services, offering legal support to artists since 1986. He authored Musicians and the Law in Canada and Music Law Handbook for Canada, Volume 1 and 2. Paul is also a co-founder, guitarist, and a songwriter for the blues group Blue Room. Without further ado, I will let you speak there, dear sir.
Thank you very much there,
Thank you.
Mike. Appreciate it. Making the effort to come here today. And yes, welcome to all of our online audience, whoever they may be. And I'm being asked today to talk about copyright. If you have any specific questions, those in the audience, by all means, ask away. But and thank you for that kind introduction. Yeah, that is what I do, just as a visual aid. That's about all I've got. That is the 4th edition of my book. And as Mike was mentioning, there are 2 other handbooks that are available online if you're looking for a more consumer-oriented discussion of some of the legal issues, for example, on producer agreements, management agreements, licensing. Today, however, we're looking at primarily copyright. So, as I like to say, and I've been lecturing in that at Metalworks for ever since they started, so over 17 into the 18th year. The basics of copyright never grow old for me, because the basics are what you need to know and what you can apply from now and into the foreseeable future. So some very basic questions are often asked and should be answered. So things like, how do you acquire copyright? What is it? Do I need to register my copyright? How long does it last? So all of those types of things I'd be happy to speak about here today. So yeah, copyright, what is it? A lot of people have some basic understanding of what copyright is. And if you use the words and just kind of flip them around and said it's the right to copy, you wouldn't be wrong. But would you be fully correct? The answer is no. So what does that mean? Well, copyright is a much more complicated legal concept than that. Copyright exists in the Copyright Act. It's by its very nature, it's a statutory-based right. Where is that right? The Copyright Act itself. So if you want to know what we think of typically as what copyright is really the monetary aspects that rewards someone who's created a work. All right? So if you're looking for the specifics of what is more than just the right to copy, you would go into Section 3.1 of the Copyright Act. And no, I'm not going to bore you with all of that technical detail, but in short, it includes the right to reproduce, distribute, make an arrangement, make an adaptation, perform in public, adapt a work from, let's say, a play into a musical, or a novel into a film, all those rights. So if you look at Section 3.1, A through J, those are the so-called monetary rights to economic copyright. And that's what we generally think of. So I like to think of copyright, not just the right to copy, but a bundle of rights that is granted under the Copyright Act. And you need to understand, you acquire copyright when you create a work, spelled W-O-R-K. Well, what is a work? Once again, a statute will give you some indication of what that is. If you look at Section 2 of the Act, and you're welcome to do that, it's all available online. Go to the Copyright Act itself. And you'll see a long listing of alphabetically of works that constitute works that can acquire copyright protection. So one of the most common misconceptions is that copyright protects ideas. It does not. It protects the form of expression, which has to be in a work, a form of a work. So artistic works, musical works, films, videos, literary works, etc. Those are what are protected under copyright. That's not enough, though. The work has to be original, and it has to be in some type of more or less permanent form of fixed form of work. So, for example, if you want to write the next great Canadian novel, you can't walk around with that in your head. You actually have to put that in writing. That's what is determined to be a work, right? So there's what's called a fixation requirement. You can't just have an idea that's in your head and expect to get that to be copyrighted. Now, in terms of ideas, you can protect ideas, but that's a whole other set of laws that has nothing to do with the Copyright Act. Nothing. It's the area of law, which I'm happy to talk about if anyone has any questions about laws of confidentiality and trade secrets. So you can protect ideas, but it's usually through what they call an NDA, also known as a non-disclosure agreement, or some other form of confidential relationship. So copyright, again, just to recap, is acquired when you create an original work, and the rights are then, what you do acquire is under the Copyright Act, there are certain exclusive rights that you have when you create a work. The work itself must be, like I said, original and fixated in a particular form of expression, and they say technically more or less permanent endurance. So that's not a very hard, shall I say, threshold to meet. Putting lyrics written down by hand or on a computer, that's enough. Doing a demo, that's enough. It doesn't have to be anything particularly, like a master recording for a song, for example. So I mentioned the word original too. That has a meaning in the dictionary. But as you might suspect, it also has a meaning in law. And the legal definition of what is original and what we would think is original under the dictionary meaning are two different things. So it's a legal test. What does that really mean? So for all intents and purposes for copyright, originality means it has to be the result of a certain amount of industry experience or knowledge, or any combination of those, and not substantially copied from another. So you break that down a bit. So you have to apply some type of industry experience or knowledge, and not substantially copyright. So that begs another issue. The moment you get into substantial copying, you get into the issue of, are you infringing someone else's work? And once again, as you might suspect, the word substantial has a legal test. What does it mean to substantially copy from someone else? It means that either on a quantitative basis, like you took too much. Let's say it was a 32-bar song and you took over half the song. That crosses the line. But let's say you only took, say, 2 bars, but maybe those are the most important bars, the motif, the hook line, right? Is that enough? Well, on a qualitative basis, yes, it could be. So that's what we're talking about. And those tests for direct copyright infringement are applied all the time, even in some of the biggest cases that we are aware of in copyright law, and they seem to be getting more frequent. Why? Because there's only so much, there's only 12 notes in the scale, and if you're Quincy Jones, you'd say there are only 7. Why? Because they're flats and sharps, right? Anyway, so, but 12 in the 12-tone scale, right, the semitones, and that's it. And only so many of those are pleasing. So it gets harder and harder to develop a song that someone resonates with and is popular, right? So that's why I think the concept, and there's so much more music being produced. We just have a glut of music. We do, and it's a very hard, it's always been a very competitive field. This has gotten even more competitive when they estimate, say, 100,000 songs a day are uploaded to Spotify alone. So that's some pretty serious competition. And yes, these days, before the internet, you might have been competing with the local bar down at the, in your same hometown. Now, you're on the web, it's worldwide. Now, that isn't that surprising because the music industry has always been a global industry. Always. It's just more accessible now than ever. So who knows where your main audience will be? It could be in South Africa or Japan, and you're here in Canada. Does that happen? Absolutely it does. Okay, back to the concept of copyright. I've talked about two attributes of it already. We talked about it's statutorily based. That's why it's so important when we see each time there's a Copyright Act amendment being proposed, there are a lot of lobby groups that are interested because they monetize their rights if they're in the statute. I'll give you an example. A very substantial amendment happened in 1997 where our statute then introduced what are called neighboring rights. That now, when you record music, there's not just one copyright in the music, which there is. There's not just two, which is in the actual sound recording, but there's a third in the performer's performance in that recording. So 3 copyrights. 3. So it's gotten more complicated. But that didn't exist before 1997. So it's still, in many ways, kind of unknown. There's only been around, resound has only been around for a few decades now, and it's still working out its reciprocal agreements worldwide. Just as a side note, the U.S. doesn't fully recognize neighboring rights. Under the Digital Millennium Copyright Act, they do recognize and set up an organization called Sound Exchange, which is extremely important for Canadians because it's a major market for sound recording royalties for sound recordings that are performed in public, but they have to be digital, right? So terrestrial radio in the States does not recognize neighboring rights, unlike in Canada, which we do and have since 1997. They also don't recognize analog recordings. Well, there's lots of great analog recordings that are not in the public domain, which is a concept I want to mention to you, because that begs the issue, what is public domain and how long does copyright last? So there's an example why the statutory part is so important. We also talked about exclusivity, or I just briefly mentioned it. The copyrights that you get under the Copyright Act are a monopoly, but they're a limited monopoly, which means the Copyright Act is this kind of balancing act between creators' rights, who created the original work, and consumers' rights to access those works. So there's a whole other concept in our Copyright Act called fair dealing that does allow consumers to access the work without paying for it. Now, what are those scenarios that might apply? For educational use, for satire, parody, news reporting, critique, and those are the main ones, and you have to fit within those exemptions. So it's exclusive, yes, and it's statutorily based, but the exclusivity is limited. The other thing that I think why copyright is so confusing to so many people is we can relate to a physical artwork, like a painting, for example. But the copyright is not in that painting itself. It exists side by side in the statute that grants copyright to that work. And just because, for example, you bought a painting doesn't mean you own the copyright. If you want to own the copyright, that has to be put in writing to be valid. That's why you see publishing agreements, record deals, they're all in writing. And then when we talk about copyrights, it's almost impossible to talk about copyrights in the actual world without talking about contracts. So copyright licenses, copyright assignments, those are all contracts. And the basics of contract law apply, all right? So the other thing, that attribute that we're looking at there is the fact that they're intangible. You can't taste them, you can't see them, you can't feel them, but they are real. They are rights in the statute, right? And lastly, the other thing that's really important to know about copyright itself, go back to what I was saying about that bundle of rights under Section 3.1. It's a very large bundle. which is the primary economic rights that you have as an owner of copyright, to exploit them and be rewarded for your efforts in creating it. But in that scenario, the work itself is, you don't have to use all of that bundle all the time. So there's another concept that you should be aware of. Copyrights are what are called divisible. Almost infinitely. Let me give you an example. Let's go back to the painting, because that's a visual idea that I think you can grasp. Now I want to reproduce that in a poster. Okay, great. And let's say I want to do it in black and white, 11 by 14, in the territory of Canada only. Good to go. Okay. Now let's say I want to take those same rights to reproduce, which I have the right to do. I'm going to grant them now for color reproductions on canvas only in North America. Can I do that? Yes. Why? Because they're divisible. You can separate these each out and make, different licenses, like I said, almost indefinitely. As long as the market's there, you can exploit them. So there's a question that was raised when I was talking here, the concept of public domain. It's a very simple concept, but it's not easy in practice. So what is a public domain? Because it goes to the issue of how long does this right last? It's a very long right. It's a very long duration. The general rule for copyright acquisition and duration is life of the creator, or in this case, the more technical word would be the author of a work. Doesn't matter whether it's music or a sound recording or film, plus 70 years after their death. That's a long time. I often think about that now, because if you've been following any of the news in terms of copyright, a lot of really major artists like Bruce Springsteen, Bob Dylan have been selling all the rights, both to their masters and their music, and all the royalty streams and all the revenue to that, right? So that gives someone like Universal or Sony that bought those rights respectively a long time before they go into the public domain, before you can use them for free. So once it's in the public domain, you don't need a license and you don't need to pay any royalties. That's why just back in 2015, which isn't that long ago, just before the last conservative government passed, and we've gone into the liberal era, if you will, Stephen Harper decided that he didn't want to see the Beatles recordings go into the public domain. And you may be scratching your head, well, why? Well, he got a letter from the head of Music Canada, who is the association that represents major record labels in this country, and said, hey, they're about to fall into the public domain. Well, that's another thing. The general rule applies to music, but it doesn't apply to sound recordings. Sound recordings, prior to 2015, fell into the public domain 50 years after the date they were made. When the Copyright Act got amended, it then became basically, and I'm at the risk of being somewhat misleading, 70 years from the date of publication. So it basically tacked on another 20 years of protection of those masters that would have fallen into the public domain. And once they fall into the public domain, they're gone. Here's where it gets complicated. And again, every type of work could have a different duration. Music is different from sound recordings, for example. Published versus unpublished works. And then you start layering different territories. Even there's some commonality, which there is, between jurisdictions like Canada and the US. Anyone that's signed on to the Berne Convention, B-E-R-N-E, you can look that up. It's an international treaty that about 165 countries in the world have signed on to. And as part of that, you acquire copyrights, in quotes, automatically. All right? There's no need for registration. There's no need for putting a copyright notice on. There's some reasons why you would want to do that, but do you need to do that? Absolutely not. It's not mandatory. But then as we go, the terms of copyrights can vary from country to country. So the US has different wrinkles on it. But those three basic premises will apply in every single country that's ratified the Berne Convention, which includes Canada, US, Japan, Europe, you name it. The vast majority of countries in the world have at least those basic protections. So public domain can be a little tricky to figure out when it happens because durations of protections have to be at least life plus 50 years, but some countries are life plus 60. We now, as of the end of 2022, are now the same term of protection as a general rule with the U.S. because of the U.S.-Canada Free Trade Agreement that was renegotiated during Mr. Trump's era, all right, when he was president. So, going back to the basics. How do you acquire it? You create an original work. Original has a form of definition. How long does it last? General rule, life plus 70. Other thing to keep in mind with that, it's life plus 70 of the creator of the work, but if you co-authored a work, think of Lennon McCartney. Lennon died in 1980. Paul McCartney's very alive. Those Beatles songs were attributed to co-writings. When will those songs go into the public domain? 70 years after Paul McCartney's death, not John Lennon's, right? Life plus 70, the last surviving co-creator. So, and again, they're exclusive, subject to exceptions. You know, I like to say, you know, the law giveth and the law taketh away. It's never one or the other. That's why sometimes it gets frustrating. If I can give a clear answer, I will. But sometimes I can't. And you go, well, it's maybe this, maybe that. And it's often determined on the facts, of course. So statutory, exclusivity, bundle of rights, divisibility, protecting the form of expression. And I've been talking long enough. And does anyone, and by the way, I'm happy to, I could talk for the rest of the weekend. So if you have any questions, please feel free. Yeah.
I've got some questions on, not specifically copyright, but one of the last speakers told me to ask you. So
I'm here, yes.
Yeah, just talking about just recording an album. I paid for it, paid the producer, paid the musicians, and it's just now on Sirius XM, so going to see some money a year from now. And there was no kind of agreement made, you know, splitting royalties or anything like that. So what is the industry standard for session musicians, for creative producer? What's the breakdown there?
Yeah, happy to, and again, this is kind of a hybrid mixture of copyright and contracts, right?
Yeah.
And this goes to the very heart of what I do in my practice every day. It's a very common area, and regrettably more expensive and complicated than you might think to sort it out, particularly if there's an issue later on. Best to do it before there's any money on the table.
I think we're all a little surprised that it's making money.
Oh yeah, so I hear it. Hey, hopefully it's a pleasant surprise, not combined with a lawsuit,
right.
which does happen because it really takes off. Then you will be arguing. But yeah, so you're looking at, if I hear correctly, some releases and a producer. You're working with a producer?
Yeah, I mean, the producer's the drummer. You know, we used his studio. I paid for it all, the whole. So that's a question. Do I split royalties after I recoup my costs? Is it net or gross kind of thing, or is it from $1?
Very good question. Now, are we speaking regarding the producer or the?
Well, I guess I'll need to know both. Like, do I pay the musicians?
Maybe what I'll do is I'll answer it generically, and then if there's something specific that you need.
Yeah,
as a general rule, you would want a producer agreement in writing.
Mm-hmm.
Why? Because a grant of an interest in copyright must be in writing to be valid. So the producer would be considered a co-author of that sound recording. Mm-hmm. So you definitely want to have it in writing. Are there lots of handshake deals that exist in the real world? Yeah, there are. Are they ideal? No, because it can lead to confusion and disputes later on. So a producer agreement usually is in writing, even if it's just a short form, you know, deal memo style. Producers, as a general rule, as the industry custom, they do not get paid any so-called royalties or back-end royalties until you recoup in full all of your recording costs. That's the industry standard. At that point, they usually get then paid what they call retroactive back to record one, and usually based on some type of royalty structure, usually a share of net receipts, however that's defined, or a percentage of what they call PPD, or a combination of the two. Right? So you do want, and you also want to have a clause in that agreement that allows you the right to use the producer's name and likeness, because that's not a copyright. That's a personality right that should be acquired. So how they're credited and what they've done, it becomes an important calling card really for the producer and a marketing thing for you, especially if you hired a name producer. Sometimes the producer has more of a name than the artist, especially if they're in their early career, and you want to be able to say, you know, Daniel Lanois or whoever, Bruce Fairburn or whatever, produce my record. And that's like, oh, well, if they did it, I want to hear it, right? So, and of course the copyright issue there in terms of you want to make sure that since you paid for it, that you, in writing, have clarified that you truly own it. Now, with the other musicians that you use, it sounds like there should be releases with those too. It goes back to what I said earlier, 3 copyrights. Those performers, after 1997, not before, because it didn't exist in the Copyright Act, it has to be in the Copyright Act to exist, right? They have rights in those performances. And they also have the right, because of that, to be paid not just a session fee, whichever it may be, whether it be union or non-union, likely non-union in this case, probably, which most of them are. But they have the right to receive neighboring rights income as a performer when it's performed in public. So if it goes on to radio or satellite broadcast or whatever, that's a performance in public, and they have a copyright in that performance. So at very least, you'd want a license to use it, and then it becomes an issue. Did you pay them out, or are they going to get that, or are you going to get that royalty as part of your feature performer naming rights? It's negotiable. Sometimes artists, I'm working on a deal right now where an artist is working with friends. They don't want, they're happy to have their friend who's paid for the record also own the performances, and they're not looking for neighboring rights or even a session fee. They did it as a favor. I get it, you know, you scratch my back and I'll scratch yours. That's the way the industry works. It's networking, right? So, but in most cases, if it's a arm's length performer that you don't know, they're a session player, they expect a session fee and likely will want to have neighboring rights as a non-feature performer. And they have every right to do that. But you'd want that in writing, some type of release confirming that.
I'm going to
yeah.
follow up. I'd like to get your email or something after. I've got a lot more questions in that avenue, if you don't mind.
Sure.
Is that okay?
For sure.
I'd like to jump to some questions about the States. Is that an area of your...
I have some knowledge about U.S. copyright law, yeah.
Canadians working in the States? Is that...
Well, this is a copyright
No, okay, I'm sorry.
seminar.
Yeah.
But a really important question, of course. I usually recommend, and I tend to restrict my practice to mostly contracts for people in Canada, Canadians mostly, but anyone that's doing business in Canada from around the world. And, of course, trademark work, which I am a registered Canadian trademark agent. And we do some corporate work, like in setting up band names and partnerships and incorporations, that type of thing. So, but yeah, a lot of our artists, I usually recommend they hire specific qualified Canadian or U.S., but often Canadian U.S. immigration lawyers have expertise and deal with these people all the time, because there's a fair lot of complexity and also relationships. So if you hire someone who's dealing with, you know, people at the U.S. immigration all the time, they're going to know the ins and outs. So I highly recommend that. So I usually recommend that someone do that specifically. But you're right. You'll need to go through the proper channels if you're going to be in the States and you don't want to be deported or banned for 5 years. You got to get a proper visa and apply and leave plenty of time to do that. So, any other specific ones? Because I have a list here of things that I wanted to, one of which I've already done with, I wanted to explode some of the most common myths about copyright. Yeah.
Hi, I just had a question for navigating, like, getting a contract about splits. Or
Yeah.
writing.
Oh, yeah. Splits. Yeah. Sure.
Yeah, just because, like, I'm in a 5-member band, and the plan for our work is to obviously just split it evenly, because we've been doing
Right.
the
Okay.
recording and most, like, all ourselves. We do have one song, though, where there was 2 other people out, like, 2 members of my band were in a different band, wrote a song, that band split up, and then we asked permission to take
Right.
one of those songs, and we're obviously going to give them credits. In
Sure.
terms of actually getting writing about splits, is it as easy
Right.
as just finding, like, a template somewhere out there? There's no, like,
There,
standard?
there are templates. You want to be careful. I look at a hierarchy here because I've been doing this for a long time. As a bare minimum, you want to get, and I'm assuming people here know what SOCAN is, the
Yeah.
Performing Rights Society. As a bare minimum, you want to get whatever splits you do have into SOCAN so that it becomes a valuable and a usable business record as to what you agreed to. If you want to go up the hierarchy, you want a song split form. Now, a song split form can be something as simple as the percentage of ownership of that song, whether it be lyrics or music or them to jointly. Further up the chain, a collaboration agreement's a little more sophisticated, which will deal with things like who gets the right to enter into third-party deals, who gets to decide whether you put in a sync license, what are the mechanical rates being. See, the split sheet won't do that, nor will SOCAN. SOCAN's only for public performing rights royalties, and in the music, you're really talking about 5 main rights and revenue sources. And you want to be able to figure out, what you don't want is someone later on to come and say, by the way, I don't agree with that sync license and I own my collective share. Can they stop you from doing that? Yes. Doesn't matter if you got a 1% share or an equal share of a copyright. Once a song is created, you all own an equal designated percentage of that undivided copyright. So I could say, no, you're not licensing it at that rate. In fact, I don't want it on the record at all. So that's why a collaboration agreement is really important when those things, or at least an addendum to your split sheet. And then at the top of the pyramid here is if you can acquire the publishing, which is very rare these days, because if you're not a publisher, why would I give you my publishing, right? But it is possible to enter into a publishing agreement with your co-writers so that there's no issue. You own the publishing, and you can administer it as you see fit. So that's unusual these days, but it's not unusual to have at least a song split form with some additional rights and or a more, it doesn't have to be a particularly long form agreement, but a collaboration agreement that sets out your rights a little more fully. So that's what I would recommend. Anything else I can add to that?
No, that answers it.
Yeah,
Good.
so maybe for those online, a song split sheet really is just little more than an acknowledgement of who owns what percentage share of the copyright to the music and or the revenue share. It usually is the same. If I get half the song, I usually get half for the copyrights. I usually get half the revenue too. Yeah, if there's no other questions, I think this, I always find this kind of fun. We already blew away the first myth. Copyrights protect my ideas. Wrong. I got a kick out of that. This is wrong. No. I can copyright a name or a title. Once again, wrong. Copyrights in a name don't exist. You're talking about trademark law. Trademark law protects the wares and services that are distinguished in the marketplace under a name, a mark, a logo, a slogan, even a sound. And copyrights, the title can be part of a work, but it's not a work itself, unless it's a separate poem, which is possible, but very unusual. So, for example, is there copyright in the title Yesterday by Lennon and McCartney? No. You can write 1,000 songs called Yesterday. You can't take their lyrics and melody, but you can use the same title. So copyright does not protect the name, doesn't protect the title. I can simply post a copyright to myself as proof of copyright. Once again, no. Copyright is statutory. You don't need to do anything. If it's original, and you have to be able to prove that, it arises automatically once it's created. So posting it to yourself, I don't discourage that, but a lot of people think, oh, well, I don't have to pay the copyright registration fee, so therefore I've gamed the system, and for the cost of a registered mail to me, I can protect all of these copyrights. No, they already have acquired protection if they're original. It's just at best trying to prove that they existed. And just because you mailed it to yourself doesn't make it original and doesn't make it the fact that you own it. It's totally rebuttable in terms of evidence. So, no. Everything on the internet is public domain, free to use. Absolutely not. You'll get yourself in some real trouble if you think that is the case. No. Not to say there aren't some things that aren't available so-called free, and some of them may be under so-called Creative Commons licenses that may be usable, but you want to be very careful. Even the Creative Commons, which is an attempt to make a copyright more usable and accessible and less costly, those do have terms to them too. They're licenses. Remember, contracts. Contracts will have terms and provision. We want to be aware of those. Anything without a copyright notice is not protected. Once again, the big X. Not true. Just because you didn't put your copyright notice on it, which, by the way, consists of C in a circle, the name of the copyright owner, Jane Doe, if that's the author of the work, and then the year of publication, not the year of creation, the year when you published it. As you might suspect, that has a legal meaning in itself. Under the Copyright Act, publishing means that you've more or less issued more than a few copies to the public. So I would think that if you've put it on the internet, that's probably enough to constitute a publication, right? So the other thing that is very confusing, you will see the C, in addition to the C within a circle, or copyright in full, you see the symbol of P within a circle. And that does not stand for music publishing. That's a misconception too. It stands for copyright in the phonograph record, not the music, not who the music publisher is. So record labels will use that symbol, and for most independent artists, you will own both. You'll own the music, the lyrics, maybe even the graphic design, the photographs. That's all protected by the C copyright. Sound recordings, the P within a circle. And by the way, there's lots of great articles out there on how to properly credit and use the copyright notices. And I recommend you take a look at them. And I do recommend you use it. Even though it's not necessary, is it valuable? Yes, it is, because it creates a deterrent effect. If you see a copyright notice on, you believe that someone is claiming copyright, and they are. So you should be aware of that. If I change someone else's work, I can claim it as my own. No way. That's not true. The right to, back into Section 3.1 of the Copyright Act, the right to make an arrangement, translation, or adaptation of a work rests with the original copyright owner. You can't do that. I can't go and take Yesterday or any other Beatles song or any other valuable copyright and rearrange it and claim it as my own without consent. And the chances of me getting that for a Beatles song aren't very good. So they're going to claim that, even if they did, they probably claim the rights to it because they have the right to make that arrangement. It's part of the essence of Section 3.1, those monetary copyrights, or so-called economic copyrights. If I legally copy 10%, it's not infringable. I can legally copy 10% of a work. Absolutely not. Once again, as I mentioned, someone no less to the stature of George Harrison from the Beatles in his first post and biggest post-Beatles hit, My Sweet Lord, got sued. What did he take? 2 bars. He even took it unintentionally, or what they call subconsciously. But he was found to have access to the work, and it was the most valuable part of the work. The work that he infringed was a girl group called the Chiffons that recorded He's So Fine. Well, the hook line of My Sweet Lord and He's So Fine were identical. He got sued, he lost, and he never made a dime off of My Sweet Lord. It all went to damages. There's more history to that case, but there's an example. 10%, that wasn't even close to 10% of the work that he took, and he didn't even intend to take it. That case also stands, and it's an American case, but the premise is valuable here in Canada, that you can subconsciously copy a work. How did they find that he did? He was exposed to it on the radio, he knew the group, it probably stuck in his subconscious, and he used it subconsciously. Does that principle apply here? Absolutely it does, in Canadian law too. Again, just because it's a U.S. law doesn't mean it will be followed here. We have separate, independent legal jurisdictions. So Canadian courts can look at U.S. case law, but not bound by them, and vice versa. It's okay to copy or publish other people's work if I don't make any money out of it. Once again, no. The fact that you didn't make any money does not mean you didn't infringe someone's work. It may go to the issue of the quantum of damages, i.e., what would it cost you for an infringement case, but it doesn't let you off the hook. You should have got a license in that case to avoid that. It's hard to prove copyright infringement. Not so. Copyright law, generally, even though there are criminal sanctions under the Copyright Act, copyright is what's called on what I like to call and is technically what they call a balance of probabilities. Like that, right? Think of the scales of justice, blind justice. Maybe yes, maybe no. Criminal, got to be beyond a reasonable doubt. No doubt there. Balance of probabilities. So it isn't as hard as you might think. Now, it can get expensive when you get into court, but yes. So, any other questions? And like I said, yes, go for it. Yeah.
So, in discussing that, exactly what you just,
yes.
I had a question before, but for the previous speaker about AI.
Oh yes, yes.
So that should be,
One of my
what
favorite
is being
topics
done
these days.
right now to combat? Because I mean, you can legally have, it makes a piece of music that you want it to sound like Ghostbusters, and use it for something for another film. So what's being done right now?
I literally have read dozens and dozens of articles about AI, so-called artificial intelligence. I even object to using the word intelligence. I don't think it's intelligent at all. You're intelligent. I'm human. You're not human. You're in a logarithm. Don't give me that. It's not intelligent. But it's very effective, and it is a tool. And it's very new days. We don't have any statutory or any legislation to help guide us yet in Canada. There is some that's been adopted early in the EU, and that's encouraging signs, because I think it truly is a battle between tech and humans. It is, at the end of the day. Are we going to let tech rule, or is it going to be there to serve us? I think it should be the latter. Technology should serve people, right? Now, it's undeniable a force to be reckoned with, and it will irrevocably change not just music, but music is usually is on the forefront, because it's so accessible and malleable and easily reproduced. So what I think will be happening is that the production side of the industry, particularly producing background music, commercials, underscores with films, TV, they're going to be massively influenced by that, and a lot of people will be displaced. There's no question. There you go. There's one of them right there. Displaced. So, but it's like anything. And now, after 4 decades of practice, I've seen a lot of change. You know, I usually like to think with this disruption, it's not like Chicken Little. The sky's not falling. We will figure it out. It took a while to figure out streaming, about 15 years, because the record side of the industry went at a double-digit decline, sales, right? Now it's been on an uptick, although streaming is a whole other thing I'm happy to talk about too. But let's stay with AI. With every change, there's both opportunities and problems. It's a crisis, right? Some people will benefit from it and some will lose. It's already proving to be, I think, extremely valuable for production and helpful. I mean, it's awesome when you think of it. They can spit out, what, 10 songs in a second? Like astronomical. There's no way we could even digest those songs. But what I've seen so far, and and I won't use the word learns because I don't subscribe to that. But as it scrapes more data, as it does, it's like a big sponge, and the logarithm takes in more. It gets better and better and better. It's harder and harder. In another 6 months, we may not be able to say, well, that's AI. That's a little worse. So I really do hope, and I think the expectation is that the laws will say, no, when it comes to copyright, there has to be a human element to it. And, you know, that's another thing. Copyright's not going to go away. Back in 1995, when I'm practicing, I had people from the Electronic Frontier Foundation saying, well, it's the Wild West, there's no more copyright. Did that happen? No. If anything, copyright's more important now than ever. So it will be so with AI. So the good news is what I've seen out of the EU, they have a couple of key things. They do favor, and they don't have a Copyright Act amendment yet either, just some guidelines. So this is still early days. So if you are using AI, it has to be identified. So that's important. And number 2, if you don't identify, there are some very stiff financial penalties. And third, there is a bias towards human input for acquiring rights. But AI is way more complicated than just copyright. It goes across, like these deep fakes. That's not copyright per se alone. It's the use of my voice. Well, I own my voice, and so do you. And you should have the right to control that, and you do. So if someone takes your voice, or I guess more importantly, a celebrity voice, because that's where the economic value is. Right now, I don't think many people would be wanting to hear my voice. It might put them to sleep at night, but other than that, you see what I'm saying? But there is value there, but it's still mine, and you can't take that right away. If you do, that's infringing my name and likeness rights. That's not copyright, right? And if you took my voice in my recording, which I do have in my band, in my solo recordings, that's copyright infringement of my music and my recordings. So you can't do that, not without repercussions. So, we're in new days, early days with it. It's going to be good and bad. It's always. Change is always the same. I mean, it's like the same thing. Do you really want to go back to the era when there was no internet? Most people wouldn't. Yes, right. And we do want refuge from technology. But as a general rule, we're way better off and way more interconnected for the technological changes. And we are in a technological digital revolution. Make no mistake about that. We're only about one generation in to the internet era. And technology continues to grow exponentially. So think about it. In the days gone by, we lived off the land, right? We did. We as society, we were agrarian. Then along comes a major disruptor, the steam engine, And all of a sudden, we're in the industrial era. People coming off the farms to live in urban environments. We're now in the IP era, and all digital technology and technology generally is in intellectual property in nature, of which copyright is only one. The other rights and main family of those is trademarks. And every musical artist or band has a trademark of some type and or a pseudonym which is a trademark, and their copyrights, but also industrial designs, the way products are aesthetically featured, and then patents for inventions. That's what's driving the economy these days. And don't let anyone tell you that copyright's just for artists and it doesn't mean anything. Based on my studies, a good 10% of the industrialized Western world GDP is through intellectual property, and a good chunk of that is copyright. Think about it. On any given day, we use computers. Guess what? A computer is protected as a literary work under Section 2 of the Copyright Act. It's a copyright. So when you think of it, you know, this isn't just, you know, for sloughed off politically a bunch of, you know, artists that don't have any economic value. That is not true. And like I said, you know, big tech is based on computer programs, and those are copyrights, worldwide recognized. So, you know, and most of us will be making our living with our minds, intellects, right? You don't have to be an academic to be an intellect or use your mind. When you use your mind to create music, that is intellectual. It's an intellectual, you know, it's emotional too and satisfying, but it's still using the mind. You're not working the field with your hands and labor. And that's where a lot of us are making our living. And that's where we're at. And society, I think, if anything, you're smart. I really do feel, now of course this is my bias, but that you need at least some fluency in very least copyright law, because it affects you every day. You write a business memo, then, you know, let alone a musical work with lyrics. What is it? Guess what? If it fits the definition of original, it's a literary work and protected by copyright under the Copyright Act. So the definition of originality it's not a high bar to meet. You don't have to be original. You have to be the next Miles Davis. You don't. And thankfully you don't, because, you know, how many of us would actually achieve that level of originality? No. But as long as it's, again, a certain amount of industry skill, experience, or knowledge, not substantially copied from another, you have acquired copyright to an original work, and you're entitled to be rewarded for that economically under the statute. I'm getting the Twister sign, which, by the way, I just saw that movie last night.
Thank you so much.
Tornado Wrangler, yes. The Twister, all right. Shall I wrap it up? Anyway, thank you for those online, and thank you for being here on this fantastic day, sunny and hot and late summer day at Gussapolooza, the wonderful festival, which I'm going to have a chance to get out and check out the vendors and the music, and thank you for inviting me, and I'd like to come back if you like it. Thank you.